Your will, write it in there. Maintain that word, because that is an expression of a sovereign. That is how we communicate with our servants. It is my will that you, my elected representative, do what I ask, put what I ask in my parliament. It's not rocket science. And when you do it as a group, you mandate them. Okay, that word mandate's been abused by politicians. But when a group expresses their will, they do that in the form of a mandate. It comes from the word mandamus. Mandamus is an instruction from a high court to a lower court. The highest court in this land is you, the people. You have the highest authority. The High Court ruled in Halford, 1917, Resch, 1943, Harding. There's a number of court cases prior, sort of 1950, where the High Court was acting under the Constitution. And it established that your interpretation is paramount. When you read a section of law, that interpretation is paramount.
As cited in Resch versus Commission of Taxation.
As cited there, this is just the third tier of our government saying what's already written and established in their constitution. Your voice, your interpretation is utmost. It overrides that of a single judge, especially. Single judges really only have authority if you give it to them. And that's under the consent. Under the law of this land, judgment can only come from your peers. That is the common man's authority. That is the common man's interpretation passing judgment. It's as simple as that. We don't rely on some bloke with a dead sheep on his head. Now, that bloke with a dead sheep on his head has got a problem because there's a conflict of interest that exists because he's paid by the state. So where is your guarantee of independence? It doesn't really exist. Because they're hurting themselves if they...
Can you ask them whether they're a public servant?
Oh, absolutely.
Have you done?
I have in very early court cases. They don't like it at all. No surprises. No. I don't know why they don't like me.
They're paid as public servants, Darryl, but they don't act like it.
Yeah, what we've got is a corporate entity that's really, it's beyond me why they've stepped into this zone, because under the public realm they had a certain amount of authority given to them by the people. But they've stepped out of that realm because they know they're so far from the Constitution at the moment. They've had to step into another zone, and that's the corporate zone.
For anyone that's interested in the Magistrates Court Criminal Procedure Rule Book, section 29, it actually states in there in the first paragraph that unless you consent to a single judge, you have to have a trial by jury. And it actually states that in the first paragraph.
Yeah, so I was taught at the very beginning of my path down the law to, when in defence in the Magistrates Court especially, always put to them that you don't consent to a single judge and you want your peers to decide the matter. And when you're rejected in that sense, you use the words, I do not consent to this jurisdiction. Okay, now, that says it all. I do not consent to this jurisdiction, because that jurisdiction being exercised by that magistrate is not defined in the Commonwealth Constitution. Okay, Chapter 3 of this Constitution describes what the courts can and cannot do. So we'll shoot to Section 71, and that's the beginning. Section 71 is the start of Chapter 3, Section 80 is the end of Chapter 3.
Would that be where you find yourself in a statutory jurisdiction?
Statutory jurisdiction can be brought about by any parliament. They can pass a law as long as it's consistent with the Constitution and, of course, the Bill of Rights.
With statutes, the statute isn't a law and there's agreement between the parties.
There has to be agreement between the parties, but when that statute is passed consistent with the Constitution, then there should be no argument, but you have the right to bring up an argument regarding your consent to that particular law, always. This is an exercise of your authority.
Would that be by disproving that there's any contract?
Absolutely, because we're dealing in a commercial sense, then the contract law does come into it, and contract law relies heavily on consent, as does the law itself, like the Supreme Court Procedure Act 1900 New South Wales. Section 3 says that consent by both parties before the matter can go forward. Unless consent is reached by both parties, then there is no case to be answered. Okay, so consent is the key to the door, and it is filtered through most legislation. And one of the things we try to achieve here is, by waking you up to what's in this Constitution and the laws that tie to it, it gives you some sort of idea then to when you are confronted with a law of a state, or even of a Commonwealth of late, you have a better understanding of what you're reading. So that you can use Section 109 and you have a choice whether to treat that law as invalid or whether you accept it. That word invalid's a key. I'd like to change, personally, I want a referendum all through Australia to change that word invalid. I want to put the word criminal there. Because I believe there's just not enough emphasis between the Commonwealth keeping the states in line. They've lost the sight of that. They're just allowing the states to do whatever they please. So what the hell is Commonwealth there for? General Minister.
Could you clarify for me, you refer to Commonwealth law and the Constitution, that's the same thing?
Yes, Commonwealth law, the Constitution is your foundation stone for all law here in Australia, and that ties itself comfortably in with the laws of England. Okay, so we inherited the laws of England here under what was called the Australian Courts Act 1828. Section 24 of that Act binds the laws of England to be used throughout Australia.
I've heard that you step into a court and you need to establish what law is being applied in that courtroom to determine what law you're actually underneath. So there's common law, obviously, that there's corporate law, or there's a whole bunch of them, isn't there? And under any of the others, does the Constitution not stand?
The Constitution is binding on every judge, on every court. It's not a matter of.
So those other jurisdictions, if you will, would be state representation.
Well, those other jurisdictions are invalid, and this is why it's important that you understand what it is, because the wording you used was key. Actually, you said when you walk into that room under a certain statute. No. We all walk into those courts with the Commonwealth Constitution holding us up. That is our defence. We are there to make sure that court operates strictly under this Constitution. If it doesn't, then it's a challenge to the jurisdiction that the prosecution's relying on. So first and foremost, and this has been established for hundreds of years throughout England and here in Australia, that you have that right to challenge the jurisdiction of the court first, and then the statute that the prosecution is relying upon. before you go into the details of whatever it is that you're there for. And it comes under what's called, in Latin, that's called a notice quo, it's Q-U-O, warranto. W-A-R-R-A-N-T-O. That is, you are there to ask and challenge the authority that is operating that particular forum. Please show me your authority. Because in lately, especially road traffic obligations, under a statute that is clearly invalid. None of the parliaments of the states have been following the Constitution to establish a law. And they've done this under the heading of their own state constitution, and they've perverted that to break down the separation of powers and basically bring about a dictatorship law. And I'll show you that in a moment. Here in Victoria, it's a shock.
Excuse my ignorance.
Yep.
Can you define for me the difference between law and statute?
A law is a law that's passed by a proper due process. And a statute, yes, through the Parliament following the due process. So, okay, let's for instance go through the process of creating a law. The Parliament, the lower house, will draft a bill. That bill will, once passed by the lower house, be handed up to the Senate. The Senate then argue it out and then hand that bill up, once they're happy with it, to the executive. Then the executive, their job is to check that against the Constitution, the law of the land. Okay. Once they're happy with that, they then, and this is where I bring you back at this moment, point. I'll bring you back at this moment to the Australian Courts Act, which is what I mentioned earlier, 1828. Now there used to be, we use the word used to be, section 21 of that act. That act said that when the executive had given the assent, the royal assent to that bill, they then handed it on to the Supreme Court of the state. And the Supreme Court of the state had 7 days, 14 days, to approve of that law. And then they applied what was called the royal seal of the Supreme Court. Then it could be used as a law. Okay, and passed 3 ticks, got the 3 ticks. Now in 1873, lawyers in England, not here in Australia, as far as what my research has uncovered, there's been no influence from Australia, but under what was called the Statute Law Revision Act 1873, they repealed section 21 of the Australian Courts Act. So in effect, the third tier of government, the courts, lost their ability to exercise their right to approve or disapprove a law that had been assented to through the executive and the parliament.
You said that's 1823.
1828. 1873, they repealed section 21 of the 1828 Act.
22 now.
Yeah, 22. 22 was it? Sorry, it was section 22 of the Australian Courts Act. Really 60s.
Sorry, could you clarify for me also how the judiciary, the lower tier, actually has a say in how some of these laws are...
Well, back in between 1828 and 1873, they had a say, and the way that we the people could recognise that law was to see that the royal seal of the Supreme Court appeared on that law. Then we knew that it had been through the 3 checks and balances, and it was a law. But in 1873, they took that away from the courts.
Now new laws are just dreamt up in the lower house.
In the lower house and assented to in the executive, and then we're supposed to accept it as law.
In the executive, it's
Yeah.
not just the parliament.
It's not just the parliament. This is the key now. In fact, if we could shoot, while we're on this, we've got your heads in this space, we'll go to section 15 of the Constitution of Victoria.
Good on you.
Yeah, I'm sorry. Throw a curly one at you. But each state has its own constitution. And every one of those constitutions is subject to the Commonwealth Constitution.